Hi, my name is Ingrid Calvin, and this is my predictive research. Um, Two guys, Mark and Jason, have been drinking. Jason dares Mark to punch him, but Mark says no. Jason grabs Mark's wrist, but Mark pulls away and ends up punching Jason in the face. The punch leaves Jason with a broken jaw and missing teeth, and Mark with a lawsuit on his hands, excuse me. So I looked up two cases to find out if Mark can argue that Jason gave consent. Could Jason counter that he only authorized a stomach punch? Could Jason counter that his intoxication negated his request? So I'm going to look for cases where consent was withdrawn or exceeded, and look for cases where consent was given while impaired. And I'll tell you what the judge did in those cases. Okay, so I use the jurisdiction Ohio. I select from here. I chose Ohio. Save. Okay. Then I put in parentheses assault, space, consent, space, fight, space, and alcohol. Taking a little time. Might have to pause. So I found my first case is going to be State versus Dunham, Court of Appeals of Ohio, 1st District, Hamilton County, 1987. Okay, in this situation, okay, it's about the victim name was Hopkins and the defendant name was Dunham. You can read that right there. Uh, Evidence supported conviction for felonious assault where defendant kicked and stomped victim upon the head, face, and neck after victim fell unconscious to the ground and lay defenseless, and victim suffered trauma to the head and eyes with probable permanent effects. After a pre-sentence investigation was completed, the court sentenced Dunham, which is him, the defendant, to a term of 6 to 15 years imprisonment. Um, the appellate's theory of law is that where two people engage in a boxing match, a mutually agreed upon fight, neither can claim that an assault and battery has been committed upon him. And that came from a case called Barholt versus Wright, 1987. Two people go out to fight with their fists by consent and do fight with each other. Each is guilty of an assault. That comes from Champer versus State, another case. Both Hopkins and Dunham were equally guilty of assault because an assault is the willful threat or attempt to harm or touch another offensively, coupled with a definitive act by one who has an apparent present ability to do harm or to commit the offense of touching. Okay, the assignment of error is overruled and the judgment of the Hamilton County Court of Common Pleas is affirmed. So the judgment was affirmed because the defendant Dunham stumped the victim after he passed out. He blacked out and he continued to beat him. So he was convicted based on that, not because of the fist fight. So the judgment was affirmed, it says right here. And then there was another case. I have to go back. Return to list. Okay. There were 20 cases in all, by the way. The next one, click on view all 20. Cox versus Phillips, Court of Appeals of Ohio, 6th District, Lucas County, March 31st, 1992. In this case, the plaintiff, Danny Cox, brought actions against the appealee, Robert Phillips, and another gentleman, Mike Hall, during a wedding reception hosted by the Yeagers and Barkers. They were the alcohol suppliers at the wedding reception at Holland Gardens, which is owned by the Halens, says right here. Holland Gardens, Robert Yeager, Mrs. Yeager, Joyce and James Barker, plaintiff, appellant Danny L. Cox sought an appeal to this court asserting the following assignments of error. Here they are. You can read that. Okay, the appellant, Phillips and Hall. The appellant is Danny Cox. Phillips and Hall, they were served alcoholic beverages sometime during a reception. The appellant was involved in several fights. Phillips and Hall admitted to hitting the appellant, Mr. Cox, once. Cox alleges that he suffered severe injuries. Appellant alleges that Phillips and Hall maliciously assaulted him. Holland Gardens and the Halens, through their employees, negligently served alcohol to Phillips and Hall when they were intoxicated, causing them to become violent and angry. Okay. The trial court granted summary judgment to appealees. Let me find where I'm reading it. Right here. That's what I'm reading from. It first held that Holland Gardens was not liable for appellant's injuries. The court found that Holland Gardens did not violate any of the statutes alleged by appellant. The court then considered the common law negligence claim against Holland Gardens as an owner-occupier of the premises, where appellant was injured. It concluded that Holland Gardens had a duty to exercise ordinary care to protect appellant from the violent acts of third persons. The court found that it was undisputed that the bartenders called the sheriff's office when they learned of the fight. Therefore, the court concluded that a reasonable jury could only conclude that Holland Gardens exercised its requisite duty of care. Okay, Holland Gardens is not liable for the injury Hall and Phillips allegedly inflicted upon the appellant because it was not foreseeable. Since Holland Gardens owned no duty to appellant, reasonable minds could only conclude that judgment should be rendered in favor of Holland Gardens. Okay, let's skip down. Appellant also, come down a little bit. Yeah, appellant alleged in his complaint that Hall and Phillips were minors and were served alcohol. However, the trial court found that Phillips was an adult and that Hall, a 19-year-old minor, drank only beer as permitted by statute. Okay. Having found that the trial court did not commit error prejudicial, to appellant, the judgment of the Lucas County Court of Common Pleas is affirmed. Appellant is hereby ordered to pay the court costs incurred on appeal. That means Mr. Danny Cox, the plaintiff, lost because the Yeagers, the alcohol supplier, which are the alcohol suppliers, and Holland Gardens which is owned by the Halens, they weren't responsible for the actions that happened to Mr. Cox. He didn't prove his case, so he was responsible for paying the court costs because he didn't prove the errors. And with the case with Mark and Jason, let's see. The case with Mark and Jason really don't have a case, and I think it should be thrown out of court because they both were engaged in a fist fight. Yes, the court would likely grant the motion to dismiss. Jason's claim is tossed out. Mark avoids liability, and that's my opinion. That's my theory. That's what I believe. Again, this is Ingrid Calvin. Thank you.